Good morning. Please be seated. We are here for oral arguments in cause number CV170768, Walsh, Alexis et al. Versus Arizona Board of Funeral Directors and Embalmers. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs, we have conferenced the case, so you can assume that we know what you're talking about, and at this point, I'd say, counsel, please proceed.
May it please the court, my name is Charles Burry. I represent the appellants in this case. If I may, I'd like to reserve 3 minutes of my time for rebuttal. There are a number of issues in this case, but the most perplexing, the most disturbing, is the bias and the prejudice that the board exhibited toward the plaintiffs. Even before, and I say plaintiffs, appellants, even before charges were brought against them, the board's executive director was telling people that the appellants were going down. Their licenses were going to be revoked. People didn't want them in the industry. And in making those threats, the executive director was acting in his official capacity. He was speaking on behalf of the board. And if there's any doubt about that, let's look at the behavior of the board in this case. When the board was advised of the executive director's threats, it summarily dismissed them. It was no surprise to them. It was meaningless. What did the board do? It turned around and filed charges against the appellants. And then the appellants asked the board to recuse itself from the administrative process and to allow the administrative law judges' recommended decision to become the final decision of the case.
But you're not suggesting that the charges themselves were frivolous. The administrative law judge found them to be substantiated.
In part, and we do contest a number of those in our briefs, but the fact of the matter is, why were the charges brought against the appellants in the first place?
Well, because there was substantiated evidence that was found by the ALJ that has nothing to do with your claim. I mean, the executive director may have made some comments, but the board is the one who found there was enough to refer to the ALJ, and the ALJ substantiated the claims. So that's why they were brought.
Okay, so let's assume there's a legitimate basis to bring the complaint. We move things along. We asked the board to recuse itself from the hearing process. The board refuses. Rather than allow for the perception of complete fairness in light of the executive director's threats, the board wanted to control the outcome of the case. And ultimately, it exercised that authority to do exactly what the executive director threatened. When the administrative law judge came back with her recommendation to suspend the appellant's licenses for a brief period of time and then place them on probation, the board rejected that notion and did exactly what the executive director said would happen. It revoked the appellant's licenses. I submit that the unfairness inherent in these circumstances was intolerably high. I mean, look at the facts. The outcome of this case was a fait accompli from the very beginning.
Could we talk about the actual charges for a minute?
Sure.
What is there in the record that would indicate that the appellants were on notice that stacking was a violation of their license?
At the time it occurred, they were not on notice. It only came to their attention after the board, and I think it was prior to the filing of the complaint, took the position that stacking was not to be done in Arizona. But back in the summer of 2015, the board had not taken a position on the issue.
Are there any regulations that would indicate stacking is inappropriate?
Not expressly, no. None whatsoever.
Are there any regulations that specifically adopt some type of trade standard or something like that that would indicate that stacking was inappropriate?
None whatsoever.
But the experts that testified on your client's behalf seem to all suggest that stacking is not something that they would do, and that it is a professional standard.
I would disagree with you, Your Honor. The board's witnesses, and there were 4, did testify that, in their opinions, stacking was contrary to prevailing practices. But it's kind of interesting. They left it at that. They never said it was contrary to prevailing practices in Arizona in the summer of 2015. And the reason why, they didn't have the background or experience to render that opinion. If you look at Mr. Starks, one of the board's expert witnesses, he never practiced in Arizona. He had been licensed elsewhere, and he had practiced for a long time, but he was not familiar with standards and practices.
So is there a different standard in Arizona on that issue?
Well, we don't know.
What was the best evidence presented on your client's behalf that it was not a standard?
Well, you had 10 witnesses who testified that stacking was common and was acceptable in Arizona during this period of time.
They didn't do it.
I beg your pardon?
I thought the witnesses said they didn't do it. They're like, oh, yeah, people maybe they do it, but I wouldn't do it.
Some did. Some did. Some were straightforward and said, hey, listen, it happens. It's been done for a long time. We do it. Others said, listen, it happens. It's been done for a long time. We don't think it's right, and we don't do it.
Anyone said that we're currently doing it? This is something that is currently being done, and in my view, it meets professional standards.
I do. If I recall correctly, I think Sandy Greenlee testified to that effect.
Did any of your expert witnesses say that they currently engaged in stacking in their business?
Again, I believe Mrs. Greenlee gave that testimony.
Okay.
But would that be a judgment call by the fact finder to if there's 1 or 2 people who say that this meets the standard, but 10 people say no, it doesn't? Would we substitute our judgment for the ALJ and the board?
Well, the question is, was there substantial evidence that stacking was contrary to prevailing practices in the funeral industry in Arizona in the summer of 2015? None of the board's witnesses gave that testimony.
Why would it be different in Arizona than nationally, stacking? Why would that be why would that be unique to Arizona?
Your Honor, I could only offer surmise. I don't know. You know, every state is different. We have different laws, different practices, different sensitivities. So I don't know the answer to that.
But are you saying we should ignore testimony from from experts who aren't in Arizona on that issue? Is there, absent some indication that there's something unique about Arizona with regard to stacking?
Your Honor, if there was a national standard, it was incumbent upon the board to have the witnesses testify to that effect. I mean, the burden of proof was on them to demonstrate what the prevailing practice was in Arizona in the summer of 2015, and they absolutely failed in that regard. On the other hand...
Only because they didn't say in Arizona, they just said this is the standard, but they didn't say in Arizona?
Yeah, I think that's absolutely correct. They would have us assume that the national standard, or whatever standard they're familiar with, is what's acceptable in Arizona. And, you know, that's a leap of logic. There's got to be evidence to that effect. I'd like to get back, if I may, to the denial of fairness, because I think...
Oh, let's stick with this for a minute,
Okay.
because I really want to press this for a minute. Was there anything in the evidence beyond just stacking? I mean, was there any evidence that any of these boxes broke or anything, or there were...
None whatsoever.
Fluids dripping or anything like that?
How about bending, anything like that?
Oh, I think there was testimony that Mrs. Moreno saw some containers in the back of a transit vehicle, and I think she opined that they may have started to bend on the corners or something like that. It wasn't terribly specific, but I do recall something to that effect. But did anything untoward ever happen as a result of stacking? There was no evidence to that effect. In fact, the evidence was just to the contrary, that nothing untoward ever occurred. And I think you can look at the testimony of Ms. Welsh, Alexis, and Mr. Warner to that effect. If I may, then, I'll turn my attention back to what I see as the unfairness.
Well, I don't mean to keep pestering you, but I am going to. Let's assume, for the sake of argument, that we find that the stacking was not adequately proven, does that mean that we have to remand, or do you believe that there has to be a reversal on other allegations that were made in order for there to be a remand?
Your Honor, I think the board's decision and order is rife with problems.
But what about if we find that there was a violation of the refrigeration requirement, would that be enough to affirm the board's decision?
I think not, Your Honor, because it just wasn't on that basis that the board chose to revoke the appellant's licenses. Also included was the stacking issue,
Transport,
things of that
We'd
sort.
have to remand if we find that there was a basis for a violation of the refrigeration directive, but not.
I believe so. Because I think that it's required that the board then reconsider its decision in light of the fewer number of infractions.
and I guess as was the genesis of my question is, given the number of infractions, if we focus only on and find, well, okay, we're not in agreement on the stacking, given the other number, isn't it an act of futility to send it back?
Well, it depends on whether the board is going to be fair and objective. I mean, if the board exhibits the same bias and prejudice it did at the onset of this case, it would be a futile act.
At the onset of this case, simply making charges, why does that necessarily establish bias when the infractions were found by the ALJ?
The infractions were found, but it gets back to the idea of, okay, assuming there were infractions, what do you do about it? What do you do about it? You know, disciplinary action isn't exacted for the purpose of punishment. It's exacted for the protection of the public. So I think that's the real question. What needs to be done? The evidence was that, for example, in terms of stacking, that the appellant had stopped stacking before the board brought charges against them once they learned of the board's position. And when it comes to the issue of refrigeration, there was only 3 instances in which people said they observed containers outside the refrigeration unit.
Wasn't it also a math issue, though, in terms of the numbers? I thought the state's, the board's position was that there's no way this could have happened. That's just the number of times people saw it, but based on the numbers that went through, they couldn't have all been refrigerated properly.
You're talking about Ms. Stapley's report, the board's investigator, and that, too, was rife with error. Her accounting initially didn't take into account the containers that were cremated each day. And when we brought that out, other problems surfaced. She didn't take into account when containers were added to the cremation list. Was it when people called and said they're ready for pickup and cremation, or was it when they were delivered? Ms. Stapley also assumed wrongly that each container remained in the possession of Saguaro for at least one day, when oftentimes the containers came to Saguaro, they were cremated that same day. And besides that, and probably the most problematic part of her calculation was she didn't take into account that some containers may have contained the remains of infants and body parts and things like that. The containers are much smaller. The refrigeration unit could hold many more. So that accounting, I don't think, went anywhere. I don't think the administrative law judge was persuaded by that, and I think that's reflected in her findings of fact.
Oh, I didn't read it that way. I mean, I have to be honest with you. I read the ALJ to find it persuasive. That in conjunction with the testimony that of the people that actually saw the refrigeration. Mm-hmm. I mean, she specifically found that there was a violation of the refrigeration requirement.
Well, she did, but I would submit wrongfully so. When you look at what occurred, you had this hostile funeral director go to the Saguaro. He says he saw containers outside the refrigeration unit on 2 visits. It happens to be the same number of containers on the same number of gurneys. And then you see we have the testimony of the board's investigator who went there once and saw containers outside the refrigeration unit. Interestingly enough, neither of these individuals asked why are the containers outside the refrigeration unit.
But counsel, all of that was presented to ALJ, and the ALJ made a determination. And you're not asking us to substitute our judgment for the ALJ, who actually heard the evidence and made a finding.
I'm asking you to find that there was no substantial evidence that these observations justify the finding that containers were not kept in refrigeration. That's the issue. Was there substantial evidence to that point?
Where you have testimony that says they're outside, that the refrigeration unit is not on, no one is there, why isn't that enough for us to defer to the ALJ's finding?
Well, again, the fact that containers were seen outside is explainable because, as the evidence...
But explainable, that means that's where we typically defer. It's somebody has an explanation. The ALJ didn't accept that explanation. Why would we substitute our judgment there?
Again, I would submit that the testimony adduced on that issue wasn't substantial. Would this be a good time to talk about a couple other issues?
You can talk about whatever you want.
I only have a couple more minutes left before I reserve. I wanted to talk about the board's finding that the appellants violated the Department of Health Services rule, former Rule 9-19-301, or excuse me, 302. That was a rule that the board read as requiring a disposition transit permit to identify the place where cremation would take place. The permits at issue some did not identify Saguaro as the place where cremation would occur, and accordingly, the board found that the appellants had violated that rule. But if we go back and look at the rule doesn't say what the board said it said. The rule only required disposition transit permits to identify the means of disposition. In this case, it would be cremation. Didn't require the disposition transit permit to identify where the cremation would occur. So there was no violation of that rule.
Is there not a problem with stating inaccurately on avowing something happened here when it didn't happen here, or misidentifying the location?
There was no avowal made by Saguaro or the appellants.
There's a signature on a form that states something that's inaccurate, right?
Well, the permits themselves are completed by the funeral home that transmits the containers to Saguaro for cremation. But the rule doesn't require the transit permit to state where cremation is going to take place. So if the rule doesn't require that, how can you conclude that the appellants violated the rule? It just doesn't make sense. It doesn't make sense whatsoever. I want to talk about the actions that were taken against Welsh, Alexis, and Lambert's funeral director and embalmer's licenses. They didn't work at Saguaro as an embalmer or funeral director. Saguaro is a crematory. It doesn't do funeral directing. It doesn't do embalming. It only does cremationists. So there was no basis for the board to act against those other licenses. Now, the board argues that, hey, the appellants can't compartmentalize their conduct. But when you look at the licensing that takes place in terms of the funeral industry, embalmers, funeral directors, cremationists are all licensed separately. It's done individually, and they're employed likewise. So just because someone may have done something wrong as a cremationist doesn't mean that that exposes their funeral director or embalmer's licenses to discipline.
Even if it's something that goes to the dignity of the deceased?
Well, you know, I would love to have the time to talk about dignity and respect, because I would submit that those standards are unconstitutionally vague and unenforceable, given the Ninth Circuit and Fifth Circuit's decisions regarding abortion rules that use similar language. I might mention just briefly, because I think I have a minute 22 left, that when it came to the revocation of Warner's cremationist license, here again we have something that just doesn't match up with law. His license had lapsed months earlier, and as a matter of law, it no longer existed. But yet the board decided, hey, we can't suspend it, so we'll revoke it. Well, unless you have explicit statutory authority to act against a lapsed license, you can't do it. Some agencies have that authority.
You would suggest anybody that was undergoing investigation by a disciplinary board to simply delay the proceeding until their license expired?
I wouldn't suggest it, but it happens. And if the person should reapply later on, certainly those circumstances could be brought up in terms of whether the individual should be relicensed.
You bring them up if you haven't gone through the process already. If you wait, say if you just wait 3 or 4 years, there's no more, the evidence is no longer available. That seems like an odd remedy.
You don't know that to be the case. I mean, it could well be present. I'd like to reserve a few seconds, so thank you very much.
Thank you. Counsel.
May it please the court, Tom Rain appearing on behalf of the Arizona Board of Funeral Directors and Embalmers.
Could you start with the stacking?
Yes.
And let us know what is it that puts people like appellants on notice that stacking is improper?
Well, I'll start out by saying that appellants are correct that there is no Arizona law or administrative code provision that specifically uses the phrase stacking. They were disciplined under Rule 412-301A1, which states, quote, licensees shall not engage in any conduct which causes or results in disrespect for the deceased person, ellipsis, I'll skip the other parts, contrary to the prevailing standards and practices of the profession in this state. The appellant's argument is that statute is constitutionally vague, and that it's basically, there's no...
Focus on the prevailing standards. Because if it's just disrespectful, that does seem pretty vague. But what evidence is there that it is the prevailing standard in Arizona not to stack?
Okay, Well, I'll go through some of our witnesses. The board, on behalf of the board, 1, 2, 3, 4, 5... We had at least 5 witnesses testify as to the prevailing standards of the profession with regard to stacking. First, I'll talk about the Arizona specific ones because that appears to be one of the arguments against this discipline. Gary Hendricks, who is the board's license administrator and an investigator, testified that on his tenure of the board, he had investigated nearly every funeral home and crematory within the state of Arizona over a number of years, and that these were surprise inspections where you just show up and knock on the door and look at the facility. He also testified that stacking was something that when he was hired, he was told to look out for. And in all those years and going to every single facility, I think he named 2 or 3 he never got to out of the 150-something facilities. He'd never seen stacking once. That's one.
But is it taught? Is this something that's taught? If it's just that no one ever does it, why would necessarily putting one box on top of another... What would put someone on notice? The fact that you haven't seen it in other places still doesn't tell me that it's a standard. I agree. It points in that direction. But is there what else is there that puts them on notice that that's a standard?
Okay, let's talk about instruction in the industry for practitioners and licensees. Donna Backus testified on behalf of the board. She's the coordinator of the mortuary science program at Chandler Gilbert Community College, which is the only school for mortuary science in Arizona. So most of the board's witnesses, not the board's witnesses, but most of actually the appellant's witnesses testified that they went through this program. She testified that at Chandler Gilbert Community College, the program specifically teaches students not to stack. It's in the lectures and it's in the written materials provided to students, which were admitted as part of exhibits here. Jim Starks, who is more of a national expert, he's the dean of the ICCFA, and that's the International Cremation and Cemetery Funeral Association, ICCFA. He's the dean of their crematory college. He teaches a cremation course every year at their big, national, I don't know what you call it, but long story short is he also teaches in their course not to stack, and they use an example of he testified that part of that course, they have a picture of two boxes stacked in a van as kind of an example of don't do this.
When we look at, you're talking about the mortuary science program, and there's
Yes.
only one, it's in Chandler.
Yes.
Once you finish that program, you take a state board of some kind, I'm assuming, to get your license?
That's correct.
And during that testing proceeding, do they talk about stacking? Is that one of the questions? Is that one of the subjects that's addressed by that licensure test?
I don't know what is it. The state board, actually Arizona State, this is not in the record though, so, but just from my knowledge of the
Just curious.
This, Arizona uses a national test. You can either take the national funeral science exam or national funeral examination, or you take the Arizona State equivalent. But the rub is that the Arizona equivalent is we use the national one. So by taking the Arizona one, you're still taking the national one. Just you're calling it the Arizona. You can only be licensed in Arizona. So Arizona does use the national test. And Donna Backus testified with regard to the crematory license or the cremationist license, which is much simpler to get than a funeral director's license. The cremationist license is a one-day program, and she testified that the test they give in that does ask a question about is stacking permitted under basically it says you may stack containers, true or false, and the answer was false. So she did testify that is in the materials. Caressa Hughes testified on behalf of the board. She was, with regard to the stacking issue, she's the managing director of SCI, which is the largest funeral company in the world. SCI has 34 funeral homes, 11 cemeteries, and 9 crematories in the state of Arizona. She testified that SCI does not permit stacking at any of its facilities in Arizona or otherwise. Ms. Hughes is also on the board of directors of the ICCFA, which we mentioned, as well as CANA, which is the Cremation Association of North America. These are national organizations, for funeral directors and cremationists, and she's on the board of directors of those companies or of those organizations. And she testified that she had received their permission from the general counsel and the board to testify on behalf of those organizations that they find stacking to be offensive and not consistent with professional standards. So there was sufficient evidence to establish that stacking was against prevailing standards. Even some of the appellant's witnesses themselves testified that they found stacking to be offensive and something they would never do. And so there was some, but appellants did present some evidence that a few people did find stacking not offensive, but the ALJ was in the best position to resolve conflicting expert opinions. Like in Phelps v. Industrial Commission, the Court of Appeals was clear that the ALJ has a prerogative to resolve those disputes. Additionally, in this case, we had another layer of review because
in terms of what's the better practice, but it seems to me you have to be on notice that this violates an industry standard. And if it's someone who's just saying, well, I wouldn't do it, I've seen other people who do it, I personally wouldn't do it. Is that enough to say that it's the industry standard?
if that was all there was, that probably wouldn't be enough. But here we have the major industry trade groups. We have the only college that teaches it. We have the largest company that operates in Arizona saying there's no stacking. We have the board's investigators saying they've never seen it. All of this evidence does reach a level where it's undeniable that is the prevailing standard. And the notice issue, it kind of runs back into the constitutional law
If
argument.
it's so clear cut, why isn't there just a rule that says that?
I don't know. I mean, that would be nice in a lot of situations, but even
And it would give everybody notice, and there would be no dispute, and you wouldn't have to call all these experts to testify about industry standards, because there's just a rule.
Well, that would be great, and maybe that would be a future, endeavor for the funeral board. But the rules, as they stand, they are what they are. And interestingly, in Golub versus Arizona Medical Board, that's in our brief. This is another case where someone challenged a statute as being unconstitutionally vague, which prohibited any conduct or practice that is or might be harmful to the public, to the health of the patient or the public. The court found that was not vague and that there was appropriate notice. And it said something to the effect of, the legislature need not define statutory terms with linguistic precision, nor need it describe every possible boundary of the statute's application.
Harmful to the public seems a little clearer than dignity of the deceased.
Let me give you another example. Etheridge versus Arizona State Board of Nursing. The Court of Appeals found this statute not vague. Failure to maintain minimum standards of acceptable and prevailing nursing practice. That reads just like the second half of the disrespect rule. You shall not engage in conduct that constitutes disrespect for the deceased, contrary to the prevailing practices and standards in the state. So, according to Etheridge, you could just the board could probably have had a rule that said you shall not engage in conduct that is contrary to the prevailing standards in the state. And that under Etheridge, that would have been
I thought it was a harm related. See, to me, it seems like a different. If you're relating a professional standard to harm, then clearly practices that could result in harm are easy to prove, and you don't necessarily have to anticipate all types of harm.
correct.
But here we're talking about dignity, and that's why I asked the question to counsel. Was there any indication that the stacking that was engaged in this case caused any harm?
Well, in this case, we have, I mean, it's a unique situation. This is much different than the medical field because here everybody's already dead, so you're not going to harm a deceased person. But but what appellants seem to be arguing is that as long as it's behind closed doors and no one sees it, I guess no one could be harmed. But as Jim Starks testified, the death care industry is built upon respect. That's the training they get. That's part of what they do. Just because no bodies happen to have fallen out of these things or were smashed in this instance doesn't mean that.
Why people shouldn't stack is because that leads to that potential. So
there was some testimony. Starks in particular testified that there could be damage to the body below. But also while stacking in transport, there could be these things can slide around, and certainly the body could be damaged. There's also testimony that these containers do leak sometimes. But the critical thing was the disrespect. There was several practitioners testified that they find it extremely offensive.
Why isn't it? It seems to me that that's more critical. That should. I find that more persuasive than just the general notion of it's disrespectful to be stacked on top of someone else. Seems to me more compelling that there's a possibility that the box is going to leak, or that if it's stacked, there would be a problem that way, as opposed to simply it's disrespectful to be underneath someone. That doesn't seem to be very disrespectful. We see in cemeteries all the time where there's stacked graves just being on top or below someone.
That may be the case, but I don't think you'll find graves where they're stacking strangers on top of one another. And the testimony, even the appellants that were
in a military installation, you have rows. Go out here to the Phoenix Cemetery, and you have rows of. These aren't families; they're just rows of people that have been.
I would have to look at that, but I would expect, and there was testimony about this, that the practitioners that testified on behalf of the board do not consider it stacking if you're putting people on racks. There was testimony with regard to appellant Frank Lambert putting up to 8 cardboard boxes of humans, stacking 3 high in the back of his van. Other experts said that's a no-no from the appellants or from the board's
perspective. That goes more to the potential for the box could break or something, as opposed to just the notion of it's the dignity of being underneath someone. Isn't that your better argument? That
may be the better argument. That's clear. Certainly, and you haven't heard appellants say much about that. I mean, it's pretty hard to argue with smashing someone underneath someone or fluids dripping. But there was substantial evidence. This was a 3-day hearing. The ALJ heard substantial evidence on the disrespect issue and found that the board's experts did establish that was a standard of care. And even in the manuals.
You have to admit that disrespect seems pretty nebulous. I mean, how disrespectful to whom? I mean, you could probably line up people in the public, and half would say, no, it's not a problem. The other half would say, oh, yeah, I'm offended by it. And there'd be some that say, I don't even think cremation is respectful.
That's all correct. But that sort of touches on the case I'd love to talk about a little bit that the appellants cited in their reply brief, that the 2 abortion cases, in particular the 9th Circuit Tucson Women's Clinic versus Eden, because I think that gets at what you're saying in that one could say, hey, disrespect is such a vague term. You and I may disagree on that. And in the Eden case, this is where they struck down an abortion statute for facilities requiring them to ensure that the patient is afforded of the following rights: to be treated with consideration, respect, and full recognition of the patient's dignity and individuality. So that's a similar statute that I think that there the court said that statute was struck down because, in particular, the Court of Appeals said that, the 9th Circuit Court of Appeals said that it subjected physicians to discipline based upon not on their own objective conduct, but on the subjective opinion of others, and that was concerning. And if this statute in particular, if Rule 412-301 only said you shall not engage in conduct that's disrespectful, period, I think you would have that would be the same sort of case there, because again, it's up to someone's subjective viewpoint. Here, it says you shall not engage in conduct that's disrespectful to the deceased, contrary to prevailing standards and practices of the profession in this state. That takes it out of the purely subjective realm to the objective realm, so that if a family member comes and complains to the board about a practitioner and says, that was really offensive the way they handled my funeral, the board will only discipline if, not just due to the subjective feelings of the family member, but they look at the conduct of the licensee and say, did you fall below the professional standards? So it's not just someone's subjective viewpoint, it's does it comport with the professional standards. And there was plenty of testimony that in the funeral industry, treating people as individuals and as though they were still alive. There was testimony that you treat them as though they're still alive, you treat them with respect. And the conduct that the appellants were saying, such as one of the appellants experts testified that they thought it was appropriate to take one box off a shelf, put it onto a gurney, and then grab another one off because they didn't want to bring it all the way down and hurt their back, so they'll just use someone's loved one as a table, essentially. Things like that, I don't see how that can be consistent with respecting the deceased, treating them as individuals.
When we talk about consistent with industry standards, et cetera, when those standards evolve, how do practitioners receive notice that they have evolved and that they must now comply with this extra step to be in accordance with your rule?
Well, as practitioners, and the case law cited in our brief also mentions this, practitioners are expected to be up to speed on the current trends within their industry. The board did, or the ALJ did find that perhaps in the remote past, 10 to 15 years ago, maybe stacking was okay, but it wasn't stacking. It was not okay currently.
Are
but
there requirements of continuing education?
Well, I was going to mention that they have continuing education just like attorneys do, and so they have, I think 12 hours a year they have to do. So I don't think that.
And is this part of the curriculum? Is stacking part of the curriculum on their continuing education? If it wasn't,
my understanding, they have, just like attorneys, I mean, you have a book of 100 courses you could take. But it is in the ICCFA's crematory, their cremation college, that's within the dean of that college testified it's in their curriculum. Was formerly MCC, now it's Chandler Gilbert. They testified that's in their curriculum. The actual companies that make the retorts, those are the ovens, it's in their written manuals not to stack, either in transport or in the facility. So this is written down in a lot of places. It's in official curriculums. The national organizations find it offensive. There's substantial evidence that stacking is contrary to prevailing standards. If you don't have any current questions, I wanted to address the bias and prejudice issue.
Before you do that, can
okay.
you address the refrigeration issue?
Yes.
Just the testimony came from a calculation done by this many bodies. Did you find that to be flawed? I mean, you were there, or you've read the transcripts. I didn't see that the ALJ thought that it was not reputable or not accurate.
If you, give me a moment, Your Honor. I can have the ALJ decision here, and it is clear that. Aha. You put me on the spot here, but I'm going to find that because that is the ALJ did specifically address that. Freezing. Yeah. I believe it's the first finding of fact. Okay. In any event, okay. I do have it, Your Honor. My time's dwindling down, but I mean.
We've reviewed it.
Yeah, you reviewed it. So it does. She does mention that at least in something to the fact that ALJ does not specify which days, but she said during at least some days during the summer of 2015, more than 31 bodies were on premises. That was basically the evidence. Consistent with the appellants that actually worked in the crematory, they were clear that they can only cremate the most bodies they've ever cremated in a day was 15, and the most they can hold is 16. So days where they had more than 31. Just by the math, they couldn't freeze them all, they couldn't refrigerate them all. And even in days when they had 31, I think, if anything, the board's spreadsheet undercounted because there are three retorts. There was testimony that there are 3 retorts in the facility and that it takes at least 2 hours for the cremation cycle. So if they had 31 bodies in a day, even if they cremated all day, they couldn't all be in the, I'm trying to how to put this, but basically only 3 should be out of the refrigerator at any one time. So the way I'm actually not rephrasing that right, but long story short is, in our brief, we discuss how likely that spreadsheet, if anything, undercounted the number of bodies. And regardless, we had 3 different instances where people showed up at the crematory and there were bodies just out, including one where the responsible cremationist Jesse Welsh Alexis went to Circle K and left. So there are statements where they're trying to reread the facts and say that we just had them out for a moment to move around things. It can't be the case if you actually left the building.
I would like to hear your response to the allegation of bias,
Okay.
Director.
So, as the court's aware, absent showing of actual bias or prejudice, the board is presumed to be fair. And all of the allegations here with regard to bias and prejudice concern statements made by the executive director. But the evidence was undisputed that the executive director did not initiate the complaints. The complaints were initiated by funeral directors in the community, and the evidence was also undisputed that the executive director did not supervise the investigation and did not participate in the strategy of the investigation, and did not conduct the final administrative decision. And appellants cite the Horn versus Polk case, which I think is completely an opposite, because in the Horn versus Polk case, you have a Pike County attorney finding a violation, not just finding probable cause, but finding a violation and issuing essentially a citation to Tom Horn, then participating materially in strategy for the case. Then the ALJ decides, and then the Yavapai County attorney then overturns the ALJ's decision back to her original decision. And there the court said you can't have the same person making the charging decision, participating in the strategy, and then doing a final administrative decision.
Same person influenced the people who are doing it, is that, so it just completely takes it out of it if it's
Yes, here we have the board. We don't, if the executive director, sent the case to OA, that didn't happen, and then participate in strategy, and then overturn the ALJ decision, then we would have that situation. But here, they've made no connection between statements made by the executive director and actions of the board or the ALJ. And in fact, when asked about the executive director's influence over the board, James Woods, who is the owner of Saguaro Valley, he said, I don't know what Rudy's influence is. He's the executive director. I don't know what his influence over the board is. So even their own witness acknowledged that their statement about the board being biased and prejudiced was speculative. And that mere speculation should not be sufficient to overturn an ALJ decision. And if the board was so biased and prejudiced, if you notice, they referred it out to the ALJ, and the board adopted the ALJ's findings of facts and conclusions of law.
It did go well beyond the ALJ's suggested punishment.
They did. I'm out of time. I'd love to talk about that, but next time. Thank you.
Thank you. Can you, if you know how, add 1 minute to the rebuttal time? That's about how long we gave you extra.
Thank you very much. That's appreciated. Let me touch first upon Horn versus Polk. Look to that case for overarching principles regarding due process. The need to have a neutral adjudication, one that's fair in appearance and fair in reality. That's why that case is cited. There were some questions asked about the material produced by the board's investigators regarding refrigeration. She produced 2 charts. One was marked as a respondent's exhibit. One was marked as an appellant's exhibit. The respondent's exhibit, the board's exhibit showed a graph charting out containers received by Saguaro on a daily basis. The second chart, again prepared by the board's investigator but marked as appellant's exhibit, showed the number of cremations that were done each day. You'll see a footnote in the administrative law judge's recommended decision talking about these 2 graphs. And she remarks that the graph showing the cremations said that you could do 18 a day, whereas the testimony was more like they could only do about 15 or 16. So she muses about why don't these 2 jive? And that's the problems with the work done by the investigator. They don't add up at the end of the day.
Counsel,
Thank you.
were there any further questions?
No.
Okay. Counsel, thank you so much for your arguments. We're going to take this matter under advisement, and we'll issue a written decision shortly. At this point, we're going to take a brief recess to prepare for our next argument.